So you're the executor of an estate. Now what? My name is Olivia Wan, and I'm with the law office of Olivia Wan and Associates. Myself and Allison Riley are the attorneys in our firm. Please visit our website, oliviawan.com. Step one is understanding the terms. Executor is probably the most commonly understood term in dealing with probate. Executor and executrix are individuals who are appointed in someone's will. Executor is the masculine tense, executrix is feminine. Administrator and administratrix are individuals appointed by the court because there's no will present. We use the term personal representative currently because this term refers to executor, executrix, administrator, administratrix, and is gender neutral. Decedent refers to the person who passed away. You are not the official personal representative until appointed by the court. So the first step is we determine if probate is even necessary. So the attorneys would need to look at what types of assets there are and how those assets are titled. And when we refer to asset, we are discussing real and personal property. Real property being land, house, personal property, vehicles, furniture, also referring to bank accounts and so forth. Please do not take any steps with the estate until you have your official recognition from the court as the personal representative. There are different ways to handle an estate, and that's why it's so important for you to consult with an attorney. Depending on the size of the estate and how assets are titled, it may be an option of small estate affidavit, Muniment of Title, probate, Affidavit of Heirship. We will assess whether there are survivorship options on accounts, such as bank accounts. Keep in mind that life insurance passes outside of probate. We will also evaluate whether there is a trust in place or a life estate deed on the property. So let's spend a minute on a small estate affidavit. This would be the appropriate procedure to avoid probate if there is no real estate tied to the estate. Bank accounts, stocks, bonds, retirement accounts, unclaimed property, life insurance proceeds with no beneficiary. If the estate is valued at less than $50,000, then this would be an option to avoid full probate. There would be a 45-day waiting period from the date of death. We must post bond equal to the estate value if bond is not waived. We must also list all the creditors on the form. You may be discharged from liability under bond once you've completed your services in two ways. One, prepare an affidavit that each debt of the decedent is paid. Two, automatically be discharged from this role after 1 year of filing. There's other ways to transfer property. Muniment of Title is a way to avoid full probate. There must be a will in place, and that real estate is the only asset in the estate. It cannot transfer personal property. Another option, if there is no will, to avoid probate, would be using the Affidavit of Heirship. Please discuss these options with one of the attorneys. 10-care release. If the individual is age 55 years old and older, regardless if the person used 10-care benefits or not, we must file a 10-care release. If 10-care has a claim and there's no money in the estate to pay the claim, the property would be sold to repay 10-care. We call this a 10-care recovery. The initial procedures for probate would be to locate the will and any codicils. You would engage an attorney familiar with probate law. About 30% of our practice is dedicated to probate. Please obtain the death certificate, and also we will need the addresses and telephone numbers of the beneficiaries and heirs. The probate process takes place in the county where the decedent last resided or owned real estate. Our law office would draft the necessary documents to admit the last will and testament to the probate court. The court will officially appoint the personal representative nominated in the will. If there is no will, documents are prepared to name a personal representative to administer the estate. There are certain notification requirements. The attorneys will notify the heirs at law and the beneficiaries. An heir at law is anyone who has a legal right to inherit the property when someone dies without a will. Beneficiaries are persons or entities you name to receive your assets. Fiduciary duty. As the personal representative, you must demonstrate the highest degree of honesty, diligence, and good faith, and act impartially toward the beneficiaries and the creditors of the estate. Please maintain accurate records of all financial transactions involving the estate. You have a duty to keep the beneficiaries informed of the status of the estate. We will provide them with documentation that is submitted to the court. At your earliest convenience, please notify the decedent's employer and obtain a final paycheck and any insurance, the decedent's accountant, investment advisors, insurance agents, and any other professionals, the Social Security Administration, Veterans Benefits, the Defense Enrollment Eligibility Reporting System. If the individual was a veteran, also a retiree, you'll notify the Defense Finance and Accounting Service Retiree Casualty Section of DFAS. If the individual was a veteran, also a current or retired federal civilian employee, notify the Office of Personnel Management. If the veteran was enrolled in a VA-sponsored life insurance policy, VA. If the individual was a veteran, a retiree enrolled in Service Members Group Life Insurance Plan, call the VA. Notify each retirement plan of the decedent. If there's no surviving spouse living in the home, file a change of address form with the post office as the personal representative, indicating where the mail should be sent. You will provide actual notice, which is required to be sent directly to a creditor, and include any information about the commencement of probate. In other words, you're going to identify debts that the decedent owns. So as the bills are coming in and now they're going to your address, you're going to respond with a notice to creditors. If notice is not provided, a creditor may come after the estate within 1 year, causing a lot of problems, particularly if the estate was closed and the assets were already distributed. We suggest that the letters to the creditors be mailed certified so there is proof of notification. We will provide you with a template letter. If you prefer, we can handle this portion for you. Otherwise, we'll be sure that you have clear instructions on providing notice to the creditors. Publish notice. The probate court is required by Tennessee law to publish in a local newspaper a notice to the creditors of the estate, informing them they must come forward with their claims in order to be paid. A creditor must file a claim with the court within 4 months. Otherwise, the creditor cannot enforce payment. Creditors who file a claim must be paid if there are assets. So please contact our office to discuss creditors, as we may be able to negotiate the claim or file an exception. A federal tax identification number will be obtained for the estate. We can no longer use the deceased person's Social Security number. So the federal tax identification number will be what we use to open up an estate checking account. Our law office will obtain this number on behalf of the personal representative. The estate checking account, once we have this tax ID number, then you will open up an estate checking account to receive all estate deposits and to pay estate bills. A detailed record of all estate transactions should be kept. No checks should be written on the estate account unless they are for the proper debts of the decedent, for taxes owed by the decedent or the estate, or for funeral or administrative expenses. The personal representative can be found personally liable if he or she prematurely pays or distributes estate assets and it turns out that there are not sufficient funds remaining to pay debts, taxes, or expenses. The personal representative cannot mix estate assets with personal assets. So to avoid complications, be sure to title each asset belonging to the estate that comes into your possession in the name of the estate. And when you sign records or checks, you will sign your name, comma, personal representative. Please make a diligent effort to identify bills. So this would include medical bills, credit card bills, utilities. Look at tax returns. It's very important that the creditors know that a probate has been opened. Please consult with one of the attorneys for further assistance. Let's discuss Social Security payment. Social Security benefits are paid a month behind. Social Security requires that a person live an entire month to receive benefits for that month. So the estate is not entitled to keep the prior month's benefits scheduled to arrive in the next month, even though the person was alive for all but one day of the month. If that prior month's payment is made because Social Security was not notified promptly of the person's death, it will have to be returned. So please be aware of these rules in case payment must be returned. Priority of claims. This means who gets paid first. First would be the cost of administration, and this includes, but it's not limited to, premiums on the fiduciary bonds, reasonable compensation for the personal representative, and also the attorney handling the estate. Next, reasonable funeral and burial expenses. Third, taxes and assessments imposed by federal or state government or subdivision thereof, and claims by the Bureau of TennCare. And then finally, all other general creditors who filed a timely claim. So after all of these individuals and entities are paid, then we look at distributions of the will. The personal representative has discretion to make distributions prior to closing the estate. However, we want you to keep in mind anticipated claims and expenses that may come in. Our office typically waits until the close of the 4-month creditor filing period. Make the mandatory distributions first prior to making distributions to beneficiaries, though not until solvency is established. So we will guide you throughout this process. Expenses of the personal representative, you will be reimbursed for expenses such as funeral or similar expenses and any expenses associated to the estate. If the will waive compensation for the personal representative, you will not be paid for your time. Otherwise, if the will did not waive compensation, you may request to be reasonably compensated, and the attorney will file a motion for you. So let's talk a bit more about identifying assets. Assets that belong to the estate are assets owned solely in the decedent's name, not joint assets. So search for property deeds, mortgage statements, and insurance policies. Please secure the property. It may be necessary to change the locks and store valuable property such as expensive jewelry, art, and weapons. Unfortunately, when notice is published in the paper, either notice of probate or an obituary, unfortunately, criminals take notice and may try to break into the property. Personal property. Please locate the registration and insurance documents to determine if the decedent solely owned the vehicle or other personal property. Do not drive vehicles registered in the decedent's name. Vehicles pass through the estate unless they were jointly owned with someone else. The vehicle must be retitled and insured. So basically, it will be parked until we go through the probate process. If the individual owned a small business, this would be identified as another asset flowing through the probate process. So if the decedent owned a business, our office must determine succession based on the LLC operating agreement or the corporation documents, depending how that business is titled. If the business is to be sold, we would employ a CPA to do a valuation to determine how much the business is worth. Please read through the decedent's mail and look for bank statements, brokerage statements. The mail should be sent to you at your address. Digital assets. If the decedent owned a computer, a smartphone, or other electronic device, determine if there's a password. Contact the company and provide letters of testamentary or administration to access those accounts. If the decedent had a will and the will waived the inventory, an inventory will not be necessary. Or if all the beneficiaries or heirs at law agree to waive the inventory. Otherwise, an inventory must be prepared and submitted to the court. We will need to determine if the decedent had a safe deposit box. You can use your letters of testamentary or administration to access a safe deposit box. Life insurance. Any life insurance payable on the decedent's death will need to be applied for by the beneficiary of the policy, not you. They would request Form 712, which is an official form to show the exact amount of death benefit. Life insurance passes outside of probate. If there is no beneficiary, or if the beneficiary predeceased, then at that point, the life insurance would pass through the probate process. Please cancel any credit cards. If there are credit card bills, particularly if the bill is sizable, we may be able to negotiate payment if they filed a claim against the estate. Estate tax. Tennessee inheritance tax does not apply to individuals who died after December 31st, 2015. However, on a federal level, there is a federal inheritance tax. It is due 9 months from the date of death if the entire estate exceeds $12,060,000 for year 2022. We will provide updates on years past 2022. So for subsequent years, you can look up the amount at irs.gov or contact our office. Disclaimer of assets. If a beneficiary disclaims an asset, the disclaimer must be filed within 9 months of death, and the recipient cannot receive the asset he or she chooses to disclaim. This is important for tax reasons. When we move toward closing the estate, this will happen after claims filed by creditors are paid, after assets are distributed, such as personal and real property, after a final tax return is filed. Then we would file a petition to close the estate with the probate court. We will also submit a statement by the personal representative, as well as receipt and waivers from the beneficiaries or heirs. Thank you for joining me in this discussion about the probate process and helping you to better understand your role as the personal representative. If you are our client, we do appreciate this opportunity to serve you. If you are watching this video online, please be aware that this video does not engage the services of the law office of Olivia Wan and Associates and does not create an attorney-client relationship. Please visit our website, oliviawan.com, or contact the office 931-232-4529.